Yeah, it's not just the case here in Illinois challenging the gun and magazine ban that we've been tracking rather closely. There's some other more nationally significant cases as well that we've been tracking, and one of them deals with a rule that the ATF put together saying that, for instance, unfinished lower receivers for an AR platform, they're only 80%. It's a chunk of metal with some holes cut out, but it's not something that's operable. You still got to drill it out and finish it off. That's why it's called, for instance, an 80% lower receiver. So they sell these. There's manufacturers that produce these, Defense Distributed being one of them. They are essentially considered like the godfathers of the so-called ghost guns because they ultimately allow for different types of schematics to be downloaded, and you put it into a 3D milling machine and it finishes off an 80% receiver. But the ATF said that those are firearms. 80% receivers are firearms, and they wanted to try to regulate those. So you have a case that was brought in federal court, Vanderstock v. Garland. And ultimately, it challenges this rule that ATF made, saying that the ATF is going above the rule of law. This isn't something that Congress approved. This is something that the ATF ultimately just made. So there were obvious concerns as to, is this legit? So you had a lower court ultimately rule in favor of the plaintiffs, but then on appeal, you had the defendants, as the Department of Justice and the ATF, go to the U.S. Supreme Court, where the U.S. Supreme Court ultimately, put a stay on, an administrative stay on this while it plays through the appellate court. So looking at the docket entry for this case in the appellate court, you've got, of course, the case being filed, on the 25th of last month, and rapidly they had a hearing on Thursday with oral arguments on the motion to vacate the injunction pending before the judges as to what happens next with this case. So they actually aired some of this, and we'll hear it now. Of course, something I think is rather fascinating is the appellate courts, they do indeed have their cases streamed online where you can go and listen to these. And here we are with some of the arguments. Here's the defense representing the Department of Justice ultimately saying, we need this because we want to enforce this rule.
Mr. Stern, I want to make sure I understand exactly what the government's written responses said. So if we grant the stay, right, of the preliminary injunction and the rules obviously in effect, is the government's plan to prosecute people like Black Hawk if they don't stop selling their parts?
Well, I mean, I can speak for ATF, which doesn't itself, prosecute. But the point is but would ATF enforce this law with take the kinds of steps that ATF can take? Yes. That's why we went to the Supreme Court.
And what about customers? So the customers thing was interesting to me because you point out that, obviously there's some people that can't buy guns, but imagine somebody who is lawfully allowed to purchase a firearm, so is not any kind of prohibited person of any sort, and just decides to buy one of these parts. The part is not made in accordance with the final rule, does not serialized, doesn't have it's indexed in violation of the rules, all the various things that the rule prohibits. So the part is clearly covered by the rule, but it's just a customer, just a normal American. What is the plan of the United States government as to that person?
There is, as Your Honor notes, we, sort of said in regard to this court's questions, unless there was a independent prohibition, right? So you're a felon in possession. Mm-hmm. Absent that, no.
Nothing is to normal people, just normal Americans, law-abiding Americans.
That's right.
Okay.
Now, this is a commercially oriented restriction. Yes, would ATF want to enforce this against manufacturers? Absolutely. That's why we've been seeking relief. But that's the relief that's what we want to be able to do.
So again, the state, as defendants, in this case, the state being the federal government, the Department of Justice defending the ATF, saying that they want the rule upheld so that they can enforce it against the manufacturers. And the state's laying out as to why. They merely want to enforce. They're not necessarily looking to prosecute, and they're not looking to go after the regular citizen consumer of a lower third or a lower receiver, rather. They're looking to really just restrict the producers of these things, the manufacturers like Defense Distributed and the other manufacturer that's involved in here as well. So the plaintiffs groups, they got up to address. There were two attorneys. The second one addressed some of the questions that were laid out there from the judge as to is the federal government looking to enforce this against the manufacturers, or are they just looking to enforce this against everybody? So here's some of that back and forth, and also touching on the issue of vacate or injunction, or how they should move forward with actions that the lower court already dealt with, putting an injunction on this.
Your Honor raised the question about whether or not the government intends to prosecute the two principal parties that are before the court. And based on the government's direct response to the court and the government's representation today, it appears that it will, notwithstanding the fact, Your Honor, that the plaintiffs, the appellees in this particular action have persuaded and convinced, based on the evidence, that the government is wrong with regards to the rule as it applies to these two particular plaintiffs, and that the plaintiffs have a likelihood of success, which obviously resulted in the initial injunction by the court. And this court, certainly has had the benefit of both the pleadings as well as the recent oral arguments, and respectfully are in a good position to understand the likelihood of success by these appellees. Your Honor, I think the government wants this court to believe that the United States Supreme Court's stay order is broad and precludes and prevents the district court or this court from taking any further action, including equity on behalf of the plaintiffs. And we would argue, Your Honor, that that's not the case, and the district court and this court retains both the jurisdiction and the right to frame some type of relief that would protect these parties during these proceedings.
So again, the appeals court there, I believe out of Texas, dealing with this case concerning Vanderstock v. Garland, and you've got the plaintiffs saying that, listen, the stay that the Supreme Court put on doesn't keep the lower courts from taking a different approach. Say they want to do a temporary restraining order that would only impact the plaintiffs who have sued. These types of things are obviously going to be rather fascinating to continue to monitor. But one thing also that definitely wanted to touch on here is the Supreme Court of the United States set to take up a Fifth Circuit Court of Appeals case in a decision about whether or not individuals facing domestic violence restraining orders are to be kept from having firearms. Those types of restraining orders aren't determined as to whether it's a jury. It's really just a court's function. But should it prevent somebody from being able to exercise their Second Amendment rights? So that's a pretty compelling case as well that the U.S. Supreme Court is set to hear in November. So it takes a while for the courts to do what they got to do, and courts move at their own pace, but I think it's something that we'll continue to monitor as well.